Good morning, everybody. We're just going to go out of order just briefly on Demoy Roper. Demoy Roper. Mr. Roper, good morning, sir. I think your attorney is here, if you'd state your name.
Yes, Jason Kaufman here on behalf of Des Moines Roper.
Mr. Roper, you're here on 8 warrants for a violation of pretrial release. You're being held no bond, and you are set before the judge on October 30th at 1:30 p.m.
Okay.
All right?
Thank you, Judge.
Thank you. All right, so let's go back in order. Francesca, is it Kedger? Keijzer? Are you Miss Kedger? I can't hear her at North Broward. Sir, I can't hear her from North Broward. Is it on? Can you say something?
Is it our speakers again?
The speaker, we have a problem with the speakers, is your speaker on?
Oh. How's that? Can you say something now, ma'am?
Hi, sir.
Can you hear me now?
We can hear you now.
Okay, I sound like a commercial, don't I?
It's AT&T, right?
Right.
Let's not talk about cell reception.
Ms. Kedger, you are being held on an out-of-state hold out of Lexington, South Carolina, no bond. You'll be going before the judge, okay?
Okay.
Thank you.
Thank you. Have a good day.
You too. Diane Washington?
North Broad, Your Honor, she's approaching.
Has anybody talked to Ms. Washington?
Judge, good morning, Adam Goldberg on behalf of the defense. I actually spoke with Ms. Washington this morning briefly. She's indicated to me, I've reviewed the PC, I've got my own concerns, but she's indicated to me that she'd like to resolve this matter this morning if the court is so inclined.
Okay, Ms. Washington, I understand you want to resolve this, and I'm willing to do that, but I had some concerns about your competency. Do you understand what's going on today?
Yes, I slightly understand. Conversely, you said that somebody thought I was crazy.
No, I never said you were crazy.
No, I understand, sir. My confidence is good.
Your competency is good? Well, do you
Yes.
do you understand what you're charged with?
No, not exactly.
Do you understand who I am? Who you're talking to?
Okay.
What I would like to do
I
is...
share the court's concerns.
Yeah, what I would like to do is...
I would like to be dismissed so I can go.
What I would like to do is transfer her to mental health court in front of Judge Ginger Lerner Wren. I do find probable cause. Her bond is $100. We're going to transfer this case to Judge Ginger Lerner Wren, see if we can't get her before Judge Lerner Wren as soon as possible. And is this, oh, I didn't sign this, did I? Oh, I see. Okay, so there's 3 pages. I'm sorry about that. Thank you for bringing that to my attention. And what about Karen Karina Herrera Sands?
She's here present, Judge. She declined the services of public defender at Maine.
At Maine, okay. Ms. Herrera Sands, you're being held on a $3,000 bond set by Judge Solomon on a violation of probation. You're going to be set before Judge Solomon very soon, okay? Thank you.
Thank you.
Sabrina Kilgo? Sabrina Gilgo?
Ms. Kilgore is here present, Judge. Judge, she declined the service of public defender.
Judge, I would only ask if you can, I'm assuming she's gonna do the same for the municipal ordinance, charge that she has as far as in the finding services of the city appointed PD.
Okay, Ms. Kilgo, we have the attorney for this city here. My understanding, you want to decline his services also at this time?
Okay.
Okay, thank you, ma'am. All right, Ms. Kilgo, you are charged with battery on a law enforcement officer and resisting or obstructing without violence and violation of a municipal ordinance. And I think that concerns kicking and damaging the vehicle, the police officer's car. I do find probable cause, and we're here to set bond. Ma'am, what kind of bond could you make?
$1,000 bond?
Do you have family and friends here?
Yes.
Were you born and raised here?
Yes.
Where do you live?
Fort Lauderdale.
Okay. State, I'll hear from the state. Are you married?
No.
Do you have any children?
No.
Do you work?
No. I'm a full-time student.
And Judge, the state just wanted to make you aware that she does have a pending disorderly and resisting without violence in front of you.
Okay. Ms. Kilgo, this is what I'm going to do. I'm going to put you on level 2 pretrial release with a, what is it called?
GPS monitor,
Not the GPS, the other one that about the alcohol.
TAD monitor.
With a TAD monitor. I also want you to have a drug evaluation and any treatment that they deem necessary. That would be on count 1 and 2. Do you understand?
Yes.
Do you have any questions?
No.
Okay, my understanding is you do live here, you have a place of residence, that's correct?
Correct.
Okay, so they'll be seeing you, all right?
All right. Thank you.
Okay.
And that's Brenda's address and also, oh, she's on the TAD monitor, that one you're on.
Yeah. Sarah Gagné?
No problem, Judge.
Thank you. Sarah Gagné? I think it's at North
Judge, I'm
Broward.
sorry, my docket says Maine, so I
Maine?
didn't speak with her if she's in North Broward.
They say she's at Maine. No?
I've been informed by the deputy judge, I guess she was transported to North Broward? So she's en route or she should be there right now?
Okay, let me take another look here. Deputy, is Sarah Gagné at North Broward yet?
I've been informed she bonded.
She's bonded, okay. Thank you. Sol Natasha Augustine Feliz.
She's here present, Judge of Maine?
Ms. Feliz, you are here charged with driving under the influence of an alcoholic beverage to the extent your normal faculties are impaired or with a breath alcohol level of 0.15 or above. That is a misdemeanor with various mandated sanctions. Your bond is $1,000. I do find probable cause. And second count, you're charged with DUI with property damage to another. I do not find probable cause on that. I'm going to ROR you on count 2. You're also charged on count 3 with DUI, drugs, or alcohol. With a $500 bond, I'm going to ROR you on that. And as to count 4, you're charged with driving while license suspended. Third offense, you have a bond of $750. Okay?
Judge, in speaking with Augustine Feliz, she's been residing in our community her whole life. She's 23 years old. She's currently employed. She works at a beauty salon as a nail technician and so forth. From what she tells me, her wages do fluctuate, so it's not something steady that she can rely and depend on. She's going to be contacting her mother. She lives with her mother in Miami Gardens. But
What are
she
you
doesn't
looking
think-
for, counsel?
Judge, would you consider pretrial
She
release?
refused to be interviewed by pretrial release last night, Your Honor.
She refused to be interviewed by pretrial release.
Well, Judge, when she came in, sometimes after thinking, having a good night's sleep, they think more clearly. I was able to explain to her what pretrial encompasses, and at this time she's thinking rationally, and she's asking Your Honor to consider pretrial. And she's, like I said, she's a graduate of Miami Central High School class of 2012, been living here her whole life, Judge.
All right, what I will do is on count 1, in lieu of the $1,000 bond, I will put her on level 2 pretrial release with a TAD monitor, an alcohol evaluation and treatment that they deem necessary. I am going to leave the $750 bond on count 4. The other 2 counts are ROR.
So GPS level 2 with the TAD, Your Honor, for count 1?
Well, I thought the TAD would be in lieu of the GPS,
In lieu
no?
of the GPS.
I'm sorry, I didn't catch that.
Okay, so it'll be standard supervision, pretrial standard supervision with a TAD monitor.
Yes.
Okay.
All right, thank you.
Thank you.
And Kelly Gutierrez,
Paul Ryan, Your Honor.
Good morning, sir.
where did they say? Paul Ryan. Good morning, ma'am. Are you Miss Gutierrez?
Yes, sir. Good morning.
Good morning. Miss Gutierrez, you are charged with burglary with a assault or battery. I do find probable cause, having read the probable cause affidavit. State, I will hear from you first.
Yes, Judge Victoria Hammonds, for the record. The state is requesting that the defendant be held no bond on this case. The victim, Catherine Palacios, advised the state that she was being threatened by the defendant as recently as Friday, and she's concerned for her safety.
When you say of Friday, you mean last Friday?
Friday before, yeah,
Yes,
Friday before the
okay.
incident, yes.
Okay.
And she does still have noticeable scratches to her face.
Do you have any background on Miss Gutierrez?
She has no criminal history.
Miss Gutierrez, what city do you live in?
Judge, I can answer that question. I spoke with her. She
okay.
lives in the city of Coral Springs, from what she's told me. She's lived here in South Florida for the last 20 years. She is employed. She works for the Social Security Administration as a reader for a disabled employee. She's told me that she's recently separated from the father of her children. The home that she lives in Coral Springs, and I don't know if it's a home or an apartment, so I should say the location in Coral Springs. She lives with her father as well as her 2 children. Her 2 children are 10 and 3. I would object to the state's request.
Well, let me ask you this. Catherine Palacios, what's the relationship?
Your Honor,
Yes.
it appears, according to the probable cause affidavit, that Ms. Gutierrez was having an affair with Ms. Palacios' husband.
Okay, so they don't live together.
No, I've spoken with her and I've advised that they do not live with
Is there
each other.
any reason that they need to contact, that Ms. Gutierrez needs to contact or have contact with Ms. Palacios?
Ms. Gutierrez, can you hear me?
Yes.
If the judge orders no contact between you and Ms. Palacios, can you comply with that?
Yes.
Your
Okay.
Honor,
Yes.
if the court, and Eric Linder on behalf of the state, then, Your Honor, if the court is inclined to not hold Ms. Gutierrez no bond, we would be asking for some form of monetary bond, but to ensure Ms. Palacios' safety, we would be asking for also pretrial release supervision with the GPS monitor.
Ms. Gutierrez, what kind of bond could you make? Monetary bond?
I would have to ask for help from my family. So
Where is your family?
my mom lives here. That's pretty much the only one that I can probably ask to help me.
She lives with her father. I see she's driving a 2016 Dodge. One moment, Your Honor. Just want to check one thing.
Here's what I'm gonna do with Ms. Gutierrez. Ms. Gutierrez, I'm gonna set $1,000 bond, but upon release, you're going to be on level 2 pretrial release with a GPS monitor. On level 2, you can go to work, you can go to school, but you are not to leave your home for any other reason, and you are not to have any contact in any form or manner with Catherine Palacios.
Yes,
Okay.
sir.
Do you understand what I mean by any form or manner?
Yes.
Okay, do you have any questions?
Would I be able to pick up my kids and stuff? You know, drop them off at school and,
Yes, I would permit that. Okay?
Your Honor?
Yes.
We would just also include the no contact order, and for the conditions of the GPS to include any places that Ms. Palacios frequents that she believes Ms. Gutierrez is aware of.
Okay, Ms. Gutierrez, when I say no contact, you can't go to her residence or her place of work where she works, anything like that. You can't call her, anything like that. Do you understand?
yes, the thing is that she is
Ma'am,
actually.
I'm going to advise you not to speak about the facts of the case. I don't know what you're about to say, but I wouldn't talk at all about your relationship with this person. If there's any contact that you have with this individual, you would need to rely on some third party to help facilitate that. You cannot have any contact with her.
Your Honor, we're asking that there not be any third party there. Unless the defense can give one, I don't see any reason why these two need to have contact with one another. They're not
Let me
related.
try again, okay? Ms. Gonzalez, or Gutierrez, I'm sorry. Is there any reason that you need to have contact with Ms. Palacios? I thought you said no.
No.
So there
There's
is
no
no reason. Okay, well, that's it. You don't have any contact.
Thank you, Judge.
Okay. Charlene St. Croix. Yes.
Sorry, I've got two things to advise the court, forgive me.
On St.
Number
Croix?
one, I'm being told that from the main jail, Judge, I'm sorry, I'm being told from the main jail, they're telling us that they can't hear us. The microphones are so loud that all they get is static. The other thing is I got another phone call during that last hearing on page 17. Anthony Sayer, I believe the call was from Ryan. They're asking if we could call that individual out of order. I don't have any paperwork from him,
Well-
nor did I know that that person was up there, and so I have not spoken with him either.
Okay, let's do one thing at a time.
Yep.
Let me take care of Miss St. Croix, okay, who's at North Broward, who's standing in front of me. And then we'll get to the, Miss St. Croix, can you hear me okay?
Yes, sir.
Okay. Ms. Croix, you were charged with possession of PVP, which I think is FLACA. I have read the probable cause affidavit. I find probable cause, and your bond is $1,000.
Judge, in my conversation with her, she's advised that she doesn't believe she can afford that $1,000. She's told me that she's lived here in South Florida for the last 18 years. She lives in North Hollandale with her mother and her son. Her son is 7 years old. Though she is not working herself, her mom is working as a nurse's assistant, so she presumably would need help from her mom to help post this bond. Judge, as this is a possession of a PVP charge, I'm wondering if the court would be inclined to release her on her own recognizance, or in the alternative, to place her on pretrial release.
My concern is FLACA is so addictive. Ms. St. Croix, are you working?
No, sir. I'm going to school.
How old are you?
26.
Do you have any children?
Yes.
How many?
1.
Does he or she live with you?
Yes, he lives with me and my mom.
Okay. What I'll do is I will release her ROR on pretrial release standard. She is to report by phone twice a week. She is to report once a month. She is also physically. She is also to have a drug evaluation and any treatment they deem necessary.
Thank you.
Okay. Thank you, ma'am.
Thank you.
Now, the next, you wanted me to take care of Paul Ryan?
Actually, Judge, we could actually scratch two, because I just got a call from Maine saying their screen went blank, and the next person is in Maine. I got a call, I think it was from Paul Ryan on page 17.
It's North Broward.
North Broward, forgive me. Anthony Sayer.
Say it.
And Judge, I don't have any paperwork, nor did I know that this person was up there, so I need more information before I can provide effective assistance to counsel on this.
It was a reset.
Mr. Sayer, good morning, sir.
Good morning, Your Honor.
I'm just looking for the paperwork.
It's, Your Honor, the clerk may have it, it's a reset. Madam Clerk? Madam Clerk? It was a reset from yesterday, I don't know, sometimes I know the clerk has to resets, they are appropriate to the file.
Here it is.
Okay.
I've got it. Of course, it's the second to the last one. Okay, Mr. Sayer, you're charged with burglary of an unoccupied dwelling, unarmed. We are to set bond on that case. You're also charged with petty theft, where the bond is $25. What is this?
It's a structure.
It looks like probable cause has already been found by a judge who set the $25 bond and the no bond on the burglary of a structure. And, counsel, you have not had a chance to talk with him?
Judge, I have not, so I don't know what his ties to the community are. I did get the opportunity now to review the probable cause. I don't have an argument as it pertains to PC. The only thing is, obviously, he's entitled to a bond on count one, so a bond would need to be set.
State, let me hear from you regarding a bond on count one.
Yes, Your Honor, just checking one thing.
And Judge, I just got a call from Main Jail, and they're all set with
Okay,
their technology.
Mr. Sayer, Mr. Sayer, I don't want to talk about the case, but I just want to ask you, where were you born and raised?
Fort Lauderdale.
Did you go to high school here?
Yeah, I went to Deerfield High.
Do you have family here?
Yeah, I got family here.
Are you married?
No,
Do you have any children?
no.
What kind of bond could your family make for you?
I can't make one.
Can you make a bond?
Yeah, I can make the bond.
What kind of bond could you make, sir?
Surety bond.
I believe the judge's question is, how much money do you think you can afford?
I don't have a checking account right now, so
Do you have a place to live?
nah, I just been staying at motels and whatnot. I was gonna call my mom and see if she'll get me out, you know?
State.
Yeah, I'm just pulling, as far as Broward, his record includes resisting without violence and battery from 2015. 04, leaving the scene of an accident where there was an injury. I'm showing, one moment, Judge. Getting a hot file alert.
Mr. Sayer, are you all right?
Yeah, I got a sore throat.
Okay, do you understand what we're doing here today?
Yes, sir.
Okay, you have any questions about what we're doing? We're trying to set your bond.
Yeah, I don't have the money for it right now.
He also 2000 from earlier this year, grand theft out of Palm Beach County, pled that out in June.
Here's what I'm gonna do. I'm gonna set a $5,000 surety bond. It must be posted for a surety. I'm gonna leave the bond of $25 on the petty theft. Thank you, sir.
Thank you.
Is this, what is this? Oh. That go to you or does it go over here? Goes to you? Okay. DeShane Smith? DeShane Smith?
Mr. Smith is here present, Judge, at Maine. I've had a moment to talk to him. He said his girlfriend will be posting his bond, Judge.
Okay. I do find probable cause. Mr. Smith, do you have any questions? Okay, thank you. Reynold Charles?
Your Honor,
medical recess.
Yeah. I spoke to the deputy up in North Broward, Your Honor, and I'm advised that it's a medical reset.
Is that him?
Is that Reynald Charles?
No, this is Lanier, the guy after him.
Okay, very good, thank you. This will be a medical reset. Mr. Lanier, you are here on two misdemeanor capiases. One is set no bond, the other is set at $150. You're set before the judge on November 3rd, 2017 at 9 a.m.
Good morning, Judge. How you doing this morning?
Good. How are you?
George Odom on behalf of Mr. McLawrence, being that he does have two outstanding cases actually coming out of your division, ironically, I would ask the court to appoint Mr. McLawrence's law office on both charges at hand.
Why would I appoint at this time?
As long as he's deemed indigent, Your Honor, he's being held in custody, he is entitled to representation.
Has he been
Unless he
deemed
refuses it.
Has he been deemed indigent?
No, Judge, but if you want me to proffer, I'll be more than willing to do so. Inquire so he can proffer.
Well, doesn't he have to fill out a clerk's form, and the clerk determines indigency?
No, Judge, according to Florida statute, the court can provisionally appoint, and he still can either, one, fill out an indigency application, or your provisional appointment will stand until his income dictates otherwise.
Okay, all right, well, I'll provisionally appoint the city, your city of Fort Lauderdale, right?
Mr. McLawrence's law office.
Right.
Yeah.
Right, but you handle the city of Fort Lauderdale cases, right?
Correct, correct.
Okay, all right, Mr. Lanier, thank you.
And Judge, if I may, I gotta get in front of Judge Usan. There's one more I would like to call out of order.
Sure.
Mr. Charlie McGee, he is, I know you don't have page numbers. Charlie McGee.
I've got it.
And-
Charles Lewis McGee?
Yes, Your Honor. He is on page 7.
Are you Mr. McGee, sir? Are you Mr. McGee? Mr. McGee, you are here also with a capias, $250. You are set before the judge on October 30th at 2 p.m.
Is there any way I can resolve this case today?
Mr. McGee, I would adjudicate you with time served.
Thank you very much.
Well, do you want to do that?
Yes, I do, sir.
Do you swear to tell the truth?
Yes, I do.
Is anybody forcing you to resolve your case today?
No, sir, nobody's responsible.
Are you under the influence of any kind of drugs or alcohol?
No, sir, I'm not.
Ever been treated for a mental illness?
No, sir, I have never been treated for mental illness.
Do you understand you're waiving your right to an attorney and a trial?
Yes, I do, sir.
And are you pleading no contest to possession of drug paraphernalia?
Yes.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty. Sentence you to 1 day in the Broward County Jail with credit for 1 day time served. Order court costs of $293, which I must do. And I'm going to give you a year to pay that. You can make periodic payments to the clerk of court. Okay?
Yes, sir.
Okay, thank you, sir.
Thank you.
Teddy Millen?
Judge, Mr. Millen is here at Maine. He is approaching. And Judge, he is inquiring if Your Honor would consider resolving his case today. And Judge, while you're you were looking for the paperwork, as far as the volume, it still sounds a little bit distorted. It's still not 100% clear. So anyone who's on the microphone or speaking, for example, my colleague at the public defender's desk, or even the state, or even at the witness stand, their volume comes in a little bit distorted. So I don't know if there's any way to maybe try and clarify the signal.
How does it sound now? How does it sound now?
It's still, I can hear you and I can understand, but it's not perfect. It doesn't seem like 100% clear.
I doubt if we're gonna get anything perfect, but, I've lowered the volume.
The people here who probably have better hearing than I do, they seem to indicate not you as much as other people when they approach the microphone.
Okay, maybe I had it up too loud. But, okay, so Mr. Millen, you want to resolve your case?
Yes, sir.
Mr. Millen, if you want to resolve your case, waive your right to an attorney in the trial, I would adjudicate you guilty. Order that you pay court costs of $293, and I would give you time to pay that.
Okay.
Is that what you want to do?
Yes, sir.
Do you swear to tell the truth?
Yes.
Is anybody forcing you to do this today?
No.
Are you under the influence of any kind of drugs or alcohol?
No.
Ever been treated for a mental illness?
No.
Are you waiving your right to an attorney and a trial?
Yes.
Are you pleading no contest to driving while license suspended with knowledge?
Yes, Your Honor.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, order that you pay court costs of $293. I'm going to give you 6 months to pay that. You can make periodic payments to the clerk.
Thank you, Your Honor.
Do you have any questions?
I'll be released today.
I'm sorry?
I'm going to be released today.
Only if you don't have any other wants or holds on you.
No, I don't.
Okay, well then, if that's the case, you would be released today.
Okay, thank you, Your Honor.
Okay, thank you.
Your Honor, if it's okay with the court, could we possibly call the domestic violence cases? Our victim advocate, she's needed elsewhere, so we can get
Okay.
out of here.
All right, yes, okay.
Thank you, Judge.
So we're gonna go to the domestic violence cases. Jamal Myers? Jamal Myers?
Not here at Maine, Judge.
Okay.
Oh,
Jamal Myers?
Just for one, Judge.
I'm
I
listening.
can't hear, someone else is speaking, so I'm trying to speak to Your Honor. As far as what I'm being advised by the deputies, I believe this is from your DV portion of the docket. Nobody advised the deputies here at Maine to bring any of those individuals. So if anyone is here at Maine, they haven't been brought at all.
Understood, okay. Can we reset these to this afternoon?
sure.
Okay, so we're gonna reset the domestic violence case, felony cases for this afternoon at 1:30. And I'll hold these documents here.
Judge,
Yes.
I'm also I'm being given a good question to ask. The deputies want to know if they're going to be handling DV this whole week, or is it just for today? So they know to bring them for the rest of the week.
Monday, Tuesday, Wednesday.
I was told Friday also, I was told just not Thursday.
Okay, hold on, I'm getting different information from different sources. Does anybody know, as far as felony DVs, what days we're handling it?
I was told every day but Thursday.
Okay, I was told every day, Monday, Tuesday, Wednesday, that the judge will be back Thursday. So, there you go.
Your Honor, but I said he'll be back Thursday only, and then he won't be here Friday.
Okay. Monday, Tuesday, Wednesday, Friday.
Friday. Okay, and one last question. Is it going to be both felony and misdemeanor, or just limited to felony?
It's only felonies.
Just felony.
Okay.
Thank you, Your Honor.
Okay. All right, so Patrick Hollinger?
Mr. Hollinger is here present. Judge at Maine.
Mr. Hollinger, you're being held on a petty theft with a $25 bond. I find probable cause. You also have an outstanding capias with a bond set at $5,000. You are to appear before the judge on October 26, 2017 at 10 a.m.
Judge, he declined to serve as a public defender, but he's also wanting to talk to your honor. He wants to try and resolve the cases today.
State, do you have any information on this gentleman?
Yes, Judge, the case that he has pending right now is in front of, Judge Brown. He has a 2017 driving while license suspended. The one that's pending is a failure to pay restaurant. A 2016 driving while license suspended, a 2010 DUI, a 2010 possession of paraphernalia, 2010 possession of oxycodone and petty theft, a 2009 possession of oxycodone, a 2009 driving while license suspended, and a 2010 petty theft, and a 2009 possession of cannabis.
Okay, Mr. Hollinger, if you wanted to resolve the case today, I would sentence you to 10 days in the Broward County Jail with credit for 1 day time served.
No, thank you, your honor.
Okay. You'll be seeing the judge. Thank you.
Thank you.
Juan Aguirre?
Judge, we're going to require a Spanish interpreter for Mr. Aguirre.
All right. Do we order one? Nobody, what's the common practice? Do you guys order one?
I've got the number.
Okay, thank you.
Your Honor,
Yes,
I also have a correction to the case number. Do you want to do that now, or?
to Aguirre?
Yes.
Let's wait till he.
Okay.
Lindsay Labardo Levine?
North Broward, Judge.
He's approaching.
This is Lindsay Levine.
Mr., is it Levin or Levine?
Levine, Levin, it doesn't matter.
Okay,
Your Honor, I spoke to Mr. Levine earlier. This is I believe a misdemeanor trespass, and if the court so inclined, Mr. Levine would like to resolve this morning.
okay, Mr. Levine,
Well, Your Honor, I don't call it trespassing, because, the problems I'm having is domestic violence in the environment is to me, and it's every day, it's nothing I got is right to say it, I can't even hold a piece of paper with a stop sign, with a picture of a stop sign road in it without it being domestic violence to me.
Mr. Levine, do you want to resolve this today or not?
Yes, sir. Yes, sir.
Your bond is.
I would like to resolve it and press charges at it too, because I can only be myself and appreciate my only parent in my household. I don't have to take over people's property and things they own like that with that kind of
Mr. Levine,
abuse,
give me a second.
Judge, I spoke very briefly with him.
Do you have any questions regarding his competency?
I'm concerned about what I'm seeing right now. If the court wants to make a colloquy prior to resolving, if the court has those concerns, you could reference him to
Mental health court?
the mental health court, correct?
Mr. Levine, we're going to transfer your case over to Judge Ginger Lerner Wren. She'll be more adept at handling your situation. And you can tell her about what's going on. I find probable cause, your bond's $100. Thank you, sir.
Thank you.
Jose Enrique Torres Aquendo. Mr. Torres Aquendo?
Me and Joe?
Do you have a Jose Enrique Torres Aquendo there at Maine?
He's here, President Judge at Maine. He's approaching.
Okay.
He's approaching, Judge.
Mr. Torres Aquendo, good morning, sir.
Good morning.
You all right?
Mom, you talk to me.
I see, okay. Can you hear me okay?
I can.
Okay, Mr. Torres Aquendo, you're being held on a $5 bond on a capias, and you'll be set before the court, okay?
Judge, he's he's letting me know he can't afford the $500, and he believes the court date that he missed was October 3rd. Unfortunately, there was an emergency that arrived. He was helping his aunt. It was post the hurricane. He was helping her aunt with help that she needed. Judge, because of that emergency situation, he wasn't able to show up. He's asking Your Honor, would you consider releasing him on this case?
Well, let me ask everybody, it's my understanding when a court actually sets a bond, you have to go back before that particular judge regarding the changing of the bond. That is my understanding of the law. And this bond was set by a judge. Let me see who it was, if it has it on here.
It's, Your Honor, if I may.
Yes.
It's from Judge Miller, and the only other thing I would note, it also appears that Mr. Torres has 2 pending felonies, one for possession of cocaine, the other for burglary of a dwelling and grand theft.
Yeah, I'm not going to change the bond. Mr. Torres Aquindo, you're being held on a $500 bond. You'll be set before the judge.
Thank you, Judge.
Carlisle Wilson?
Mr. Wilson is approaching, Judge.
Mr. Wilson, you're being held on a $100 bond for a petty theft. I find probable cause. You're also charged with resisting or obstructing without violence and committing a theft. What is that third count? I couldn't figure that out.
It's resisting the recovery of property.
Of the actual store employee, right? And on those 2 counts, you're being ROR'd, so your bond is $100? Thank you, sir.
What Mr. Wilson advised me, normally the $100 wouldn't be a problem. Unfortunately, when he was arrested, all his inventory, all his property was placed in the vehicle. He believes right now his vehicle may have been towed or anything like that. He has no access to his property. He has no way of contacting his friends or family to post his bond because one of the items that was put in his vehicle was his phone, so he has no way of calling anybody. So normally this $100 bond, which he would be able to afford, he's in a predicament right now, and he cannot. He's asking, Judge, if you would consider an ROR on this case.
State, does he have any priors?
Yes, Judge. He has a prior driving license suspended from 2012, 2010 driving license suspended, 2010 possession of cocaine, 2002 possession of cocaine from 2010, 2008 resisting without violence, a 2008 possession of cocaine violation of probation, 2005 fleeing and eluding and driving license suspended, 2005 resisting without violence.
Okay, I'm not going to release him ROR. Thank you, sir.
Judge, can I address a matter out of order?
Yes,
On the domestic violence docket, which we reset for this afternoon,
yes.
on page 1 of that docket, at the bottom is a Jeremiah Johnson. Obviously, Mr. Johnson's not present, but these folks are here in the gallery. They've asked to speak with me. I understand it's the defendant's mom, as well as the alleged victim in this case.
Okay.
Mr. Woods. And Judge, I've advised them that the hearing has been reset for this afternoon. They've advised they cannot return this afternoon. However, Mr. Woods advised that Mr. John, who's the alleged victim in count 1, that the incident did not occur the way that it's written up, that he never took a swing at him or took an aggressive fighting stance towards him, that he is not in fear or was never placed in fear for his own safety. From what he's advised me, Mr. Johnson apparently is on medication and maybe was not on his medication that day. He's advised me that he's not afraid of his safety. He does not wish to press charges, and actually, as I read the probable cause affidavit...
Counsel, let me just interrupt you for a minute. You're going to be here this afternoon, right?
Judge, I personally will not be here this afternoon, but what's more important is that Mr. Woods will not be here this afternoon, and so if the court wants to...
The only reason I interrupted you, it sounded like you were proffering what he's going to say, what you could do this afternoon, but if you're not going to be here...
Right.
Okay.
So, Judge, I guess my point is that if the court wishes to hear from Mr. Woods while he's present in the courtroom, I think that would make it would assist the
Mr.
court.
Woods, I'll hear anything that you would like to say, if you would want to come up. You don't have to repeat everything that the council just told me, but is there anything else that you would like to tell me?
Well, he's a good kid. He has kids, and he have a little mental problem. I don't want all these charges down on him to see him in prison. Them bad charges. And he never was a threat to me. He's a threat. He was a little threat to himself at that moment from not taking his medication. So,
well,
I did call officers 3 times before I had to grab him. So they can do a little bit more with him. But by him talking, they locked him up.
Mm-hmm.
That's basically it. That's what the officer told me. They was gonna let him go, but he's all hyped up, and so he's got his own stuff locked up.
Okay. Anything else?
That would be it.
Okay, listen, thank you very, very much for coming and being patient, waiting for us.
Okay, thank you, sir.
Appreciate it. Okay.
And the other thing, Mr. Woods, if I may inquire, you heard my proffer, what I said to the judge, is that what you said to me?
Yes.
Okay, is there anything else that you said to me that I didn't say to the judge?
No.
Did I mischaracterize what you said to me in any way?
Everything we
Okay, thank you.
got. Thank you.
All right. Let's go to Nicholas Simons, or Simmons. Mr. Simmons? Yes. Good morning, sir. Mr. Simmons, you're being charged with trespass. You're being held on a $25 bond. I have read the probable cause affidavit. I find probable cause.
Judge, well, my understanding is, I believe this may be Mr. Simmons' first offense. He's a registered voter here in Broward County. He lives in Hallandale. Been living in the same apartment for 8 years now. He's 27 years old. He obtained his GED at South Broward High School, so he has ties to the community.
Counsel, let me interrupt you. Is the address on the booking sheet, the probable cause affidavit, is a correct address?
What's the address? I don't have the booking sheet.
114 Southeast 8th Street, apartment 104 in Hallandale Beach, Florida. Is that your address, sir?
Yes, it is.
How long have you lived there?
About 8 years.
8 years?
Yeah.
Okay, and if you're released, is that where you're gonna reside?
Yes.
Okay, I will release him ROR.
Your Honor, we would ask for an order that he not return to this residence because,
Okay.
I mean, if he has a residence for 8 years, some of these allegations don't really make sense. That they found him there with a mattress,
Mr. Simmons?
water bottles, a phone charger. It sounds like he might have been squatting there.
Mr. Simmons, you cannot return to the address of 500 Southwest 11th Avenue in Hallandale Beach, okay?
Yeah, it's fine.
Okay, thank you. Paul Main?
Paul Main, come on up. He's approaching, Judge. Mr. Main, to your pleasure, he's asking Your Honor if you would consider resolving this case today.
Let me just take a look at his DO record.
Yes, Judge.
It looks to me as the charge is driving while license suspended with knowledge. Mr. Main, if you wanted to resolve this case today and waive your right to an attorney in the trial, I would adjudicate you guilty on driving while license suspended. It would be a first offense within 5 years, but you have a prior back in 2010 in Broward County. I'd place you on 6 months administrative probation, which means that upon your release, you'd have to go sign up for probation. They're gonna charge you a one-time fee of $50. You do not have to report after that, but you will be on probation for 6 months. If at any time during the period of probation, you show probation a valid driver's license or a valid driving permit, your probation would automatically terminate.
Okay.
Do you swear to tell the truth?
Yes, sir.
Is anybody forcing you to do this?
No.
Are you under the influence of any kind of drugs or alcohol today?
No.
Ever been treated for a mental illness?
No.
Do you understand you're waiving your right to an attorney?
Yes.
Do you also understand you're waiving your right to a trial?
Yes.
And you're pleading no contest to driving while license suspended with knowledge?
Yes.
The court's going to accept your plea, find that it's freely and voluntarily given. The court's going to adjudicate you guilty, place you on 6 months administrative probation, order that you pay court costs of $293. I'm going to make it separate and apart for probation and give you a year to pay that. And I'm going to place on the disposition that if at any time you present to probation a valid driving permit or valid driver's license, your probation will automatically terminate. Do you have any questions?
No.
Okay, thank you, sir.
Your Honor?
Yes.
Just for record purposes, and so the clerk can advise or whoever needs to appoint, do you want to handle if there's a future violation of probation? Do you want to address it? Because the case is assigned to Judge Levine, but you sentenced him, so I mean, this is sometimes the issue out of this division of probation.
I would have no problem with that.
Okay, so I would just, Your Honor, if you could advise the clerk that the case be transferred to you.
Okay, Madam Clerk? Okay, thank you. Okay.
Judge, one other matter on this, because this is kind of unusual as far as resolving a case through probation here at magistrates. I don't know if there's a cost involved, usually a cost of supervision. I don't know if an administrative probation carries the same cost. If he's going to afford a bond out, I don't know if he's going to be able to afford a cost supervision.
Okay, let me explain, okay? Sir, upon your release, you're going to have to report to probation within 24 hours. You have to report one time. They're going to assess you a fee of $50. You do not have to pay it at that time. You do not have to report after that. You will not be assessed a $75 cost of supervision fee every month. Do you understand? Okay, I hope I'm not boring you.
One for yes, two for no, so one is yes.
Okay, thank you, sir.
Judge, and where does he go to report to probation?
Across the street where everybody reports to probation, right across the street at the main probation place. Okay? Kelvin, right? Oh, I'm sorry, yes.
This is on Mr. Aguirre on
Yes,
page
I have it
6.
right here. Juan Aguirre,
And Your Honor, I did have a PC argument on him.
Juan Aguirre.
and if you'll raise your right
Yes, Your
hand, do you swear to translate from Spanish to English and English to Spanish?
I do, Your Honor.
State your name.
Gabriel Sinisi, court interpreter.
Mr. Sinisi, thank you for coming and helping us.
My pleasure, Your Honor. Thank you, Your Honor.
Mr. Gary? You are being held on a $100 bond for a capias.
Está siendo detenido por una petición de arresto de $100.
It looks like on a municipal ordinance.
Parece que es por una ordenanza municipal.
You are also being charged with resisting or obstructing without violence with a $100 bond.
También está siendo acusado de resistir u obstruir sin violencia por una fianza de $100.
And trespass of property other than the structure.
Y entrado permanencia ilícita.
And a bond has not been set on that count.
Y no se ha fijado fianza por ese cargo.
I do find probable cause on the two, the resisting and the trespass.
Sí dictamino que existe motivo fundado para la entrada ilícita y la resistencia a la autoridad.
State, do you have any particular request on the trespass?
¿Fiscalía tiene alguna petición en particular con respecto a la entrada ilícita?
Your Honor, the only thing the state would be requesting is that he be ordered not to return, obviously,
Okay.
to the business.
Okay.
Other than that, however, the court
Okay.
wishes to proceed, this is fine with the state.
And Judge, I've got probable cause argument as to count 2.
The resisting?
Yes.
If the interpreter may interpret.
Excuse me.
El fiscal ha dicho que lo que pediría que no regrese al negocio, salvo que si el juez tenga alguna otra condición, y el abogado público o defensor público ha pedido que tiene una petición de disputa con respecto al motivo fundado.
On the second page, the reason I found probable cause was on the second to last paragraph, where he refused to provide his name and date of birth or home address.
¿Por qué encontré motivo fundado en la segunda página, en la penúltima párrafo, que rehusó a dar su nombre y dirección de su residencia?
And Judge, I don't believe that those actions, if that's the basis of the finding, I don't believe that those actions alone would constitute an additional criminal charge of resisting without violence. He's got an ultimate Fifth Amendment right.
Okay, here's what I'll do. I'll ROR him on that charge and set a $100 bond on the trespass. Your bond is a total of $200, sir. Thank you very much.
Y el abogado público ha dicho que no cree que esas dos razones serían suficientes para encontrar el motivo fundado, y el juez le ha dicho, bueno, va a ser libertad bajo palabra para ese cargo, y para los otros dos cargos va a ser una fianza de $200. Muchas gracias.
Judge, and just so I'm clear, on count one, it's not a no bond hold, it's a $100 capias. On count two, it's an ROR, and in count three, it is not a no bond hold, but a $100 bond. Is that?
That is correct.
Thank you, Judge.
Y para estar seguro, señor juez, para el primero va a ser $100 de fianza por la orden de arresto, para el segundo cargo va a ser libertad bajo palabra, y para el tercer cargo no es una detención sin fianza, pero va a ser una detención de fianza con $100. Eso es correcto.
Judge, I would be asking you if you would consider on count 3 an ROR as well. Mr. Aguirre, when he was arrested, he had over $100 in his property. By the time they
Counsel, I already considered that. I have already considered what you're asking me, and I've already set the bond.
Well, I want to give you additional information to think about, Judge. He's living in Davie. He has a valid address. He resides in a trailer. He works in landscaping. He has no one to contact. The only person that he can post his bond is himself, and that's why I'm not asking you to touch count 1. What I'm asking you to do is on count 3, ROR him as well.
That motion is denied, and also, sir, I must order you not to return to the AZ Food Store at 13140 State Road 84 in Davie.
Señor, entonces ha habido una charla entre su abogado y el juez. El abogado peticionó que lo liberen bajo palabra, pero el juez ha dicho que ha considerado eso y va a quedar como ha decretado el juez. El juez también le ha ordenado que no regrese a AZ Food Store, que está en 13140 State Road 84.
Thank you.
Gracias.
Kelvin Wright?
Mr. Romero, do you have anybody else in there who needs a Spanish interpreter?
Oh, I'm sorry.
I can inquire, Judge.
Okay.
Oh, you're on. I'm sorry, and on the Mr. Aguirre? That's where we
Yes,
have
we're
the
going to need one
correction
more
for the case
individual
number.
that requires a Spanish interpreter, Judge.
Okay.
You have the correction for the case number there?
Okay, so on Mr. Aguirre, what's the problem?
On count one?
There's a correction for the case number on count 1.
Okay.
It's 1500467MO308.
Okay, just eliminate that 10, right? Okay.
Thank you.
All right, and who is the other gentleman that needs a Spanish interpreter?
Antonio Gonzalez at Maine, and I'm trying to locate what page number
He's on page 15.
Antonio Gonzalez? Here it is, okay. Mr. Gonzalez, good morning, sir.
Señor González, buenos días.
We have Mr. Sinisi here from Court Interpreters.
Tenemos aquí al señor Sinisi de la Oficina de los Intérpretes del Tribunal.
Mr. Gonzalez, you're being held on 2 capiases, one a misdemeanor, one a felony.
Señor González está siendo detenido por 2 órdenes de arresto, una delito menor, otro delito mayor.
The misdemeanor is a municipal ordinance case.
La falta o el delito menor es una ordenanza municipal.
Your bond is $50.
Su fianza en ese caso es $50.
You're also being held on a felony capias,
También está siendo detenido por una orden de arresto de delito mayor,
no bond.
sin fianza.
You are set before the judge
Está fijado ante su juez
on October 26, 2017 at 11 a.m.
el 26 de octubre del 2017 a las 11 de la mañana.
Thank you.
Gracias.
Kelvin Wright?
Thank you, Honor. Have a
Okay,
good day.
Mr. Sinisi, thank you very much for helping us. Good
Thank
to
you.
see you.
My pleasure.
Mr. Wright, you are being held on a $50 bond on a misdemeanor capias. It's a violation of a municipal ordinance. Thank you very much. You must post a $50 bond that was set by the judge. Jonathan Slocum? Mr. Slocum, you are being charged with driving under the influence. Second offense, your bond is $1,000. You're also being charged with driving under the influence of alcohol to the extent your normal faculties are impaired or with a breath alcohol of 0.15 or above. Your bond is $1,000. I find probable cause. And you're also being held no bond on a violation of probation or community control. Okay, sir? Thank you.
Yes, so
Judge, I would ask, it appears to be one act of driving, and as the court's well aware, oftentimes the state will arrest and charge multiple counts of DUI, and that the ultimate resolution, only one.
I will ROR him on count one.
Thank you, Your Honor.
Emmanuel Courtois?
Mr. Courtois is here present, Judge Germain.
Mr. Courtois, you are being charged with burglary of an occupied dwelling. Bond is to be set. You're also charged with criminal mischief under $1,000, which is a first-degree misdemeanor, and also trespassing of an occupied structure. In both those cases, there has been no bond set on those two charges. I do find probable cause, and I'll hear from the state regarding the burglary charge.
Judge, I've got a PC argument as to count 3, the trespass.
Okay, but I think I just said I would hear from the state regarding the burglary charge on bond.
Okay. Your Honor, we don't have him on our list of pretrial. If you could hear from pretrial regarding his criminal history.
Okay.
2010 adjudication grand theft, 2011 adjudication battery on an officer and obstruction of a police officer, 2012 adjudication grand theft and driving while license suspended, 2013 adjudication burglary dwelling, occupy. End of priors, Your Honor.
Okay. Mr. Romero, do you have any concerns regarding competency or mental health issues here?
At this time, no, but fortunately, with our ERU division, an attorney will be speaking to him soon, and they'll make the appropriate, they'll look into that issue, Judge.
I just raise it because of the probable cause affidavit, what is written there. I just was wondering if you had spoken with him and.
I have some information to share before Your Honor determines the amount of bond.
Okay, and so state, what kind of bond are you asking for?
The state is requesting a $15,000 bond and no victim contact or return to the incident location.
Okay, and Mr. Romero, I'll hear from you.
Judge, Mr. Cortez is 43 years old. He's right now not working. He's looking for work. He was previously working for a labor pool. He got paid daily, and he was making about $50 per day. Unfortunately, at this time, he has no money to make new property. He lives in Hollywood. He shares an apartment with his aunt. They've been residing in the same location for about 2.5 years, and their monthly rent is around $850 per month. The only person that he's going to be able to contact to post his mom is his aunt. And from what he tells me, she works at the airport. He doesn't exactly know how much she makes, but he doesn't think it's a lot. We'd be asking you to consider somewhere in the neighborhood of a $2,000 bond on count 1 and leaving the 2 standard bonds in place on counts 2 and 3 if you make a probable cause determination on count 3.
Well, there hasn't been standard bonds set on counts 2 and 3, which are misdemeanors.
Right, I believe the document indicates no bond necessary at this point.
No, it indicates what?
No bond necessarily, no bond necessary at this point.
Right, right. Having read the probable cause affidavit, I'm very concerned about Mr. Catoy, and I find that he's a danger to the community. What I'm going to do is grant the state's motion. I'm going to set a $15,000 bond on count 1, ROR on count 2 and 3. That'll take care of the no PC.
Right.
But also, if he is released, if he posts the bond, I am going to order that he report to pretrial, that he be placed on level 1 pretrial release with a monitor. He is not to leave his dwelling for any reason and without court order. And he is to have no contact with the alleged victim in this case, and he is not to return to that location, her address for any reason. Thank you.
So, Your Honor, did you find no PC on 2 and 3?
No, on count 3.
Okay, only on count 3.
Justin Flowers?
Mr. Flowers is approaching, Judge, he's at Maine.
Mr. Flowers, you're being held on a $1,000 bond on the possession of burglary tools, and a bond has not been set on the loitering and prowling. I do find probable cause. Mr. Flowers, can you make the $1,000 bond?
I have to try to be in contact with my family. I'm not from here. And that's why we were gonna ask you, Judge, if you could sign a phone order, so therefore you can try and get in touch with his friends and family to post his monetary bond.
Sure. If you'll prepare an order, I'll sign it.
Sure, a phone order, I can do that, Judge. I also have a PC argument on the whole case. Quite frankly, I don't see where these gentlemen are allegedly acting in a way or in a manner that is in any way unlawful. The probable cause states, I observed 3 black males matching the description turn to start walking on the corner of Military and 48th. I don't see why that behavior, based on what's written here, would give rise to the safety of the community. And then furthermore, I don't understand how the material that's allegedly recovered from Mr. Flowers would constitute burglary tools. Allegedly, he's recovered with a glove or a pair of scissors, and also a window punch. I don't see any activity described here where these individuals are allegedly near any property.
I do find probable cause. The bond is going to remain at $1,000. Thank you, sir. Soros Hall?
Mr. Hall, come on up, please.
Mr. Hall, you're being held to be heard on a bond on a robbery by sudden snatching. If I remember, it involves a cell phone. I do find probable cause. State? Where? Oh, there you are. I'll hear regarding the robbery.
The state would request a $10,000 bond and no victim contact.
Does he have any priors?
Yes, Judge. A 2009 delivery of cocaine, 2016 no valid driver's license, a 2003 delivery of cocaine, 2002 grand theft, 2001 resisting without violence, 2001 trespass, resisting without violence, 1993 robbery, a 1993 robbery, a 1993 grand theft, a 1993 robbery, 2 counts, another 1993 grand theft, 1993 burglary, a 1993 grand theft, 1993 grand theft, 1993 robbery, 1993 robbery, and then a 1993 burglary.
Okay, defense, Mr. Romero?
And Mr. Hall, if I heard the state correctly, believe the last violent prior was back in 1993, over 10 years ago, if my math is correct, Judge. He's been residing in South Florida basically his whole life. He works for a company called United Moving Company. He's been working for the same company now for 3 years, making $9.75. He lives with his mother in Pompano Beach. They've been residing in the same location for 7 years. What's important to him is right now, not now, but his mom is paralyzed, she's disabled. He helps his mother get around, do all her errands, things of that nature.
Mr. Romero, if I can interrupt you just for a moment, what is the relationship, if you know, between him and LaTelia Smith, the alleged victim?
I know.
Judge, that's a person that he's not going to have any sort of contact, abiding by any court order you should deem appropriate. As far as no contact, it's not going to be a problem at all. As far as any sort of living, any sort of contact, or anything of that nature, Judge.
I have very, very limited facts on this case. It's only like maybe 3 or 4 sentences. And I'm not getting a real feeling about how this case came about. State?
Your Honor, just some additional information I want to provide the court. One, Mr. Hall in 1993 was convicted of 4 separate strong-arm robberies, during one of which he was also convicted of committing a battery over a victim over the age of 65. On those robbery charges, he was sentenced to 12-year state prison. Additionally, just over a month ago, Mr. Hall was arrested on a possession of cocaine and is out on a $500 bond.
Okay, Eric, let me ask you, as to my question.
Yeah, no,
Do we have any more facts regarding?
If you'd like, I could call the alleged victim and see if I can get some more information. Other than that, I don't know anything I could do right now to satisfy the court.
I'm gonna put Mr. Hall back on recall, if you could find out what's going on here. Mr. Rivera, have you had a chance to look at the probable cause affidavit?
No, I have not.
Okay,
He doesn't have those documents in the.
okay. I'll read it because it's very, very short, okay? The defendant knowingly and intentionally did take the victim's phone with the intent to permanently deprive her of her property. The defendant did this by snatching the victim's phone out of her hand as she tried to walk away from him. After he was made aware of the taking, the defendant ran from the scene but returned shortly thereafter to retrieve his beer. That's it. That's why I just need more information. So can we put him on recall for a few minutes?
Yes, sir.
Okay. Blake Bogus?
Judge, on Mr. Bogus's case, there's an individual here in the courtroom, Rocky Gianta, who is the head of the Lighthouse crew. He would like to address you as it pertains to placement.
Okay, Mr.
He declined the services of public defender.
Okay. Mr. Bogus, you're presently being charged with possession of alprazolam, otherwise known as Xanax. Your bond is $1,000. Yes, sir, and I'll hear from you. What is your name?
Good morning, Judge. My name's Rocky Junta. I'm the administrating manager for the Lighthouse Crew program here in South Florida. What I'm asking today for Mr. Bogus, he's in our program. I spoke with his parents last night. They're asking through me to ask you for a custody-to-custody release on a pretrial basis, committed to the 6 months at our program with a curfew of 10 o'clock at night so he can go to work.
Mr. Bogus, did you hear that?
I did hear that.
Would you abide by that?
I would, yes.
Okay. Let me just get, what is the name of your organization?
The Lighthouse Crew.
Okay, and where is it located?
We're located at 225 Southwest 23rd Street, Fort Lauderdale, right next door to the 12-step house.
Now, I can, as a condition of his bond or his release, order him there. I can't order him there for any specified period of time. It would be pending the resolution of this case.
Okay.
And which I don't know how long it will take.
Okay, as long as he understands it's a custody release.
Right.
And he has to abide by our rules.
And Your Honor, as far, and on Mr. Bogus, he's originally from Maryland. Evidently, he's in Florida for drug treatment.
Right.
So technically, he has no ties to the community here.
And what I would like to do is put him on pretrial release, standard, with him reporting twice a week by phone, once a month in person, with the provision that he be transferred custody to custody to the Lighthouse crew.
Yes, the Lighthouse crew.
Does pretrial have any problem with that?
We can do the we have no problem. If the court ordered the supervision, Your Honor, we'll supervise.
Okay.
The only thing I would ask, Your Honor, is that a condition of his release be that the court order, and I'm not saying that they wouldn't, I just want to make it part of his release conditions, that if he violates any of the rules or conditions of where he's staying, that they be ordered to notify pretrial release so that a warrant could be prepared if they choose to.
Okay. All right, so what I'm going to do is grant the motion. I'm going to release him ROR to pretrial release, standard pretrial release. He is to be transferred custody to custody from the Broward County Jail to Lighthouse Crew at 225 Southwest 23rd Street.
Yes, sir.
Couldn't read it. In Fort Lauderdale. He is to remain there until further order of the court. He is to abide by all their terms and conditions. We would ask Lighthouse Crew to notify pretrial release if he leaves the premises or violates any of your terms and conditions.
Absolutely. Thank you, Your Honor.
Anything else? Mr. Bogus, do you have any questions?
No.
Okay, so we'll get that written up and we'll take care of it, okay?
Thank you, Judge.
Thank you for coming
appreciate
down.
that. Nice new courtroom you have here.
Oh, yeah, we enjoy it.
That's great.
Your Honor?
Yes.
Go back to Mr. Hall's case if Your Honor.
Oh, great, okay. Mr. Hall?
Yes, sir.
Yes.
Your Honor, I just got off the phone with Ms. Smith, who's a listed victim. She advised me that her and Mr. Hall used to be in a relationship. They broke up approximately 6 months ago. She advised me she was at her home. Mr. Hall showed up uninvited, became upset because apparently he's been trying to call her and she's blocked him from her phone. He became agitated. He took her phone. I know it says in here, he returned shortly after to retrieve his beer. Her phone was not recovered. She did say that his mother gave him money for the phone, but her phone is still out there somewhere.
So I figured that that's what was going on.
Hold on. Judge,
What is that? Hold on.
Something at the jail.
Is it here? It's not here. It's not here, right? No, Judge, it's not here at this jail.
Okay, so that was my concern. Mr. Romero, based on that, what do you recommend?
Judge, we'd be asking you to consider $1,000. Like I said before, some of his priors are dated, the violent offenses. There's always two sides to every story. We'll find out whose phone it actually was. But most importantly, he stayed at the scene. He remained at the scene, Judge. Be quiet. And that to me shows he's not a flight risk. He's looking forward to his day in court. $1,000 bond for this type of fact pattern. That's what I'm asking you on.
Your Honor, he didn't remain at the scene. And I know the court has the allegations. I just want to make it clear. He did not remain at the scene. He came back later and.
Okay, what I'm going to do is set a $2,500 bond. If he is released, he is to report to pretrial release, level 1. He is to report by phone twice a week.
Wait, you're on a level 1, it's GPS.
I'm sorry, standard.
Standard, okay.
I misspoke. Standard pretrial release. He is to report pretrial release by phone twice a week, once in person a month. And Mr. Hall.
Yes, sir.
You are not to have any contact by in any form or manner with Letitia Smith. Do you understand that?
Yes, sir.
That would be a violation of the conditions of your bond, and you would be remanded back into the custody if you contact her, either by Twitter or email or texting or Facebook, or go over her residence or place of work, anything. Do you understand?
Yes, sir.
Okay, thank you.
And that's no victim contact, Your Honor?
I'm sorry?
That's also no victim contact?
Yeah, that's what I just was going over
Okay.
with him.
And the bond was 1,000, you said?
2,500,
25, okay.
2,500 with standard pretrial release.
Just a
custody Thank you.
Yves Gennard,
Not to be able to do with that, that's the scene.
Mr. Gennard, come on up, please. He's up, right, Judge?
Mr. Gennard, you are being held on a $750 bond for petty theft. I find probable cause, and you're being held no bond on a violation of probation. They're going to set your first hearing violation of probation in the division where the probation is being held, okay?
Yeah.
Thank you, sir. Patrick Wells,
He's approaching, Judge. He's here in a minute.
Judge, I've got a PC argument as to count one.
Mr. Wells, you're being held for possession of cocaine, a third-degree felony. Your bond is presently set at $1,000. You're also being charged with drug paraphernalia, where no bond has been set. And I think that your PC argument is the fact that it wasn't tested. There was no indication of what it was, right?
Yeah, well, it appears that the pipe tested positive for cocaine. It doesn't look like there was any other cocaine that was recovered except the positive test on the tube. I would argue, Judge, that that positive test indicates that that pipe is, if the allegations are to be believed, drug paraphernalia, then so that there would be probable cause to warrant count two, not count one, Judge.
All right, I'm going to find probable cause on both. And let me ask you, as far as the bond, Mr. Romero, can he make it? $1,000?
Unfortunately not. He's homeless. However, he does have a mailing address, so he can still receive notice. I'd ask you to take into account this is a residue case. He's going to come to court. I'd ask you to consider an ROR. He has a mailing address.
What is the mailing address?
Just say your mailing address. 66 North Riverside Drive.
626? Okay,
Your Honor?
Your Honor?
yes.
Mr. Wells currently has an outstanding warrant in Virginia that was issued January 27th of this year.
Additionally, Your Honor, he's been arrested twice in Broward County this year for failing to appear in court. Apparently, the mailing address isn't really working well.
Is he being held on the Virginia?
It's
warrant?
probably,
It's probably limited. They'll probably only pick up within that area.
It's limited, Judge.
yeah,
It's
no,
limited.
it's just the issue is he has a history of not showing up in court.
What do you
Yeah,
recommend?
in-state pickup only.
Your Honor, frankly, with two cases already this year, I'd ask that the $1,000 bond be kept in place. If he can't bond out, he'll have a second look, and then it can be reviewed in a few days. But at this point,
I'm going to release him ROR on count one. Alex Pierre?
Mr. Alex Pierre, come on up, please.
Mr. Pierre, you're being held no bond on a felony warrant from 2014. You're scheduled to be seen by the judge on October 25th at 9 a.m. Thank you.
Good luck, sir.
Linwood Ray?
Mr. Ray, come on up, please.
Mr. Ray, you're being held on a total of a $4,000 bond on 2 counts of uttering a false instrument and 2 counts of grand theft. This is pursuant to a capias issued by Judge Lynch. Your total bond is $4,000. Thank you.
Judge, and speaking of Mr. Ray, I believe this is a not in custody capias, so therefore you do have the jurisdiction and authority to go ahead and modify the bond. Judge, at this time, in speaking with Mr. Ray, he's from Vero Beach. He says right now, financially, he has no one he can contact to post his bond here in Broward. He's asking Your Honor to consider an ROR.
And Judge, it's the state's position that he does not have any ties to the community. His place of address is listed as Tampa, and he was brought here from Tampa. So it's our position he would pose a flight risk. And he also does have priors out of 4 different states, including California, Texas, and New York.
I'm going to leave the bond at $4,000. Thank you. Charles Cole?
Mr. Cole, come. He's approaching, Judge.
Mr. Cole, good morning, sir.
Good morning, sir.
How do you feel?
I feel great. My grandfather was Russell J. Cole, commander of the PE Air Force. He won the war for us, our great country. I worked at the Navy Yard 20 years, Philadelphia Navy Yard, 10 years, New York Shipyard. My neighbors is all against me. Just because I prune my trees with my knob. Don't talk about the facts, sir. Don't talk about the facts. I served in Vietnam, 6 years. I'm a dedicated soldier. Congressional presidents put honors and badges on me of valor. I mean, why am I being treated?
It doesn't. Mr. Romero, let me hear from you.
Judge, as he said, he's a veteran. He served from 1969 through 1975.
Before we get all into that, I feel there's a mental health component here that needs to be dealt with. What can we do on this?
Respectfully, like I said, we at our in our division take a proactive approach. We go ahead and put an alert. That alert signifies an attorney's going to go talk to him that much faster to get all of his mental health history, so we can make the appropriate recommendations or to see if we have to contract with anyone. So that issue will be dealt with, Judge.
Okay. Let me ask State, what are you recommending on this?
Your Honor, first, Your Honor, the state's going to be requesting, based on the level of violence, a $10,000 bond, no victim contact, pretrial release with a GPS monitor should he post his bond. Your Honor, acknowledging that we really just don't have as much detail as we need really to make a more informed decision.
Mr. Romero, let me ask you this, if I could. What if I was to set this like for tomorrow for a second look? Would that attorney be able to get to Mr. Cole and interview him and find out what's going on, maybe contact the family, or even if I set it on Wednesday? I'm concerned for a number of reasons regarding his mental health.
I mean, we would, if you could hold on 1 second, I'm going to talk to my colleague right now.
Okay.
Your Honor.
Let's wait for him.
Yeah,
to
no,
come
I just
back.
want, yeah. See if we're dealing with it now.
Judge, we could go ahead and put this on the second look docket for tomorrow.
Okay.
And what I'm going to try and do is I'm going to try and have him interviewed right now.
Okay,
But at this time, Judge, we still have to at least designate a bond at this time.
Well, is your paper in there?
let me just ask everybody, does anybody feel that,
Your Honor.
hey, hold on just a minute.
Okay, yes, Judge.
An order for emergency transport for Baker Act evaluation would be in order?
I have no objection if the court is inclined to order that.
Judge, we're not seeking that, and I would object to that. I don't think that this individual has met the criteria for imminent harm to self or others. He's obviously been
Did you read this
arrested.
probable cause affidavit?
I read the probable cause affidavit, and Judge, I don't have a PC argument as it pertains to if the court wants to find probable cause the arrest.
No, I mean as far as him not being a danger to the community?
I mean, he's been arrested, he's removed from the alleged environment, he's incarcerated at this time. I don't think we've heard sufficient information from this particular individual to see that he warrants involuntary commitment at this point. We would object to the court
Well, it would be
sua sponte Baker acting.
A Baker Act evaluation, isn't that what the order says? And then they make a determination as to whether, let's see.
Judge Bo, you can also request that he be transported to North Broward or psych evac, and then let North Broward determine.
Okay, that's what I will do. Thank you very much.
Thank you, Your Honor.
So I'm going to order that he be transported to North Broward. In the meantime, as far as a bond, I'm going,
Oh, Your Honor, that's why I wanted to address the court. Your Honor, the rules of procedure state that the hearing must take place within 24 to 48 hours. So if you want to reset it to tomorrow afternoon, as Mr. Romero has requested, you're still within the procedural guidelines to determine a bond at that time. And this is under.
I'm not requesting it. Your Honor inquired if you could put it back on the second look docket and someone can interview him. And that's what I said we could do. But I'm not requesting him to be recalled or this hearing to be postponed. What the law says is basically probable cause must be found. And if there is no probable cause found, the state can ask the court for an extension in time. But I'm not asking for it, Judge.
Okay, even if he's not asking for it, Your Honor.
here's what I'm going to do. I do find probable cause. I'm going to set this for a second look tomorrow, at, I guess at 1:30 is our second look docket.
Yes.
And, if you'll have somebody from, the PD's office interview him, and we'll transfer him to North Broward. Okay.
So they need to have a bond set right now.
I'm not gonna set one. I'm not gonna set one right now.
Okay, it would be over the defense objection. At this time, you're holding him no bond.
Right, Judge, if, I'm sorry.
Ways to hold the person no bond. One is if he's arrested for a PBL offense.
Okay, Mr. Romero, okay, I'll set $100,000 bond, done.
You want our $100,000 bond would be tantamount to no bond. He's entitled to
Philip
a bond.
Razikoff?
Judge, we would object to the court setting the bond at $100,000.
Philip Razikoff? Philip Razikoff?
Yeah, this is for Vasquez, thank you.
Mr. Razikoff, you're being held on, for possession of oxycodone with $100,000 bond, possession of THC, $1,000 bond, and possession of cannabis less than 20 grams, $100. What is the difference between possession of THC and possession of cannabis?
It's just different, the substance, Your Honor.
It's a different substance? Isn't the THC part of cannabis?
I believe that in this case there were two separate, the cannabis was in a different form and then the THC was in a brown hard form that would be more of like a wax substance, I believe.
Your Honor, in some situations, THC can be removed from cannabis.
Okay. All right, I do find probable cause. Your bond is a total of $2,100, sir.
Judge, would you consider at least on counts two, to reduce it to $100 on count two?
Isn't possession of THC a misdemeanor?
No, it's a felony, Your Honor.
It is.
Yes. And, yes.
What did you want on count two?
$100, Judge. He lives with his mom. He's gonna have to contact his mom to post his bond. He works for a moving company, so he doesn't have them financial resources.
Does he have any priors?
I'm checking that right now, Your
His
Honor.
mother, I spoke to the mom this morning, Your Honor, the mom's posting the bond.
Judge, even though the mom's posting the bond, of course, any mom would probably post any bond for their child if they have the capability. Whether, just to make it things easier on the family, would you consider reducing from $1,000 to $100?
I will consider reducing it to $500, so it'll be $1,600 total.
Thank you, Judge.
Jesse Pierre?
Keep the question, Judge?
Mr. Pierre, you're being held on aggravated assault with a deadly weapon. I've read the probable cause affidavit. I find probable cause. I will hear regarding bond, Mr. Romero.
I'll let the state go first, Judge.
The state would request a $10,000 bond and no victim contact with Ryan Foley.
Oh, does he have priors? Do you know what his history is?
Yes, Judge. He has a 2015 battery on law enforcement, a 2000, I'm sorry.
He has a 2011 adjudication aggravated assault on law enforcement officer or firefighter, Your Honor.
I'm sorry, I couldn't hear you because of the...
Your Honor, in 2011, aggravated assault on a law enforcement officer, he violated probation, was sentenced to 5-year state prison. 2014, fleeing and eluding law enforcement, 2-year state prison. Possession of cocaine with intent in 2010. Those are the, from what I can tell, the most significant priors, Your Honor. And Michelle, do you show when he was released from state prison?
When he was released?
Yes.
So what kind of bond are you asking for?
He was released from state prison October 16th of 2016. And I don't know if the state mentioned the 2000. He also had a conviction for fleeing and eluding lights and sirens.
Yes, yeah.
You mentioned that one?
Yeah.
Okay.
And Your Honor, based on his criminal history, the state would actually be, and the alleged use of a firearm in this case, the state would be asking for a $20,000 bond, no victim contact. Should he post his bond, that he be released by, that he be supervised by pretrial release with a GPS monitor and an additional condition, even though he's not legally allowed to be in possession of one based on his prior convictions, that he not be in possession of any firearms or weapons or ammunition until further order of the court.
Defense, Mr. Romero?
Judge, he's going to be living with his sister in Hollywood. He does a tree service. The average is about $200 per week. There's no way he's going to be coming up with the, I guess initially the state said 10, now they've changed it to 20. Judge, the only thing he could probably afford is somewhere in the neighborhood of $1,000, Judge.
Of what, 1,000?
$1,000.
1,000. Okay. What I'm going to do is, I've read the probable cause affidavit. I find probable cause. I will set the bond at $20,000 if he is to be released. If he does make the bond, he is to be released to pretrial release, level 1 with a monitor. And he is to have no contact in any form or manner with the alleged victim in this case until further order of the court. Thank you. Donnell Latimer?
Mr. Latimer, is your present, Judge?
Mr. Latimer, you're being charged with possession of cocaine. You're being held on a $1,000 bond. I find probable cause. You're also being charged with possession of cannabis less than 20 grams, drug paraphernalia. Pedestrian failed to cross and crosswalk. Is that a state misdemeanor?
Judge, I don't think that, I'd have to look it up. I don't think it's a criminal offense at all. I don't want to misrepresent that to the court, but.
I would assume it's either state or.
Yeah.
I mean, it's a state statute, but.
It's an infraction, Your Honor.
It's an infraction?
Yeah,
Okay.
infraction.
All right. Your bond right now is a total of $1,000. Can you make that, sir?
No, sir. He cannot. He's a day laborer, Judge. Whenever he can work, he lives in Fort Lauderdale, he lives in a trailer. He's been residing there for about a couple months now, so he does have a place to stay. What do you consider standard pretrial, Judge?
And Judge, yeah, the other thing that I would add, just as to count two, the possession of cannabis, I'd make a probable cause affidavit. It's something I mentioned earlier in the proceedings. Apparently, only it is the pipe that tested positive. There was no separate cannabis that was recovered. Obviously, the court could still make a finding of probable cause, but I'd ask you to take that into consideration in considering Mr. Romero's request.
Mr. Latimer, can you make any bond at all?
No, sir, I don't have any money.
Let me ask you this. It says on the booking report that you're at large, that you don't have an address. Is that accurate, or do you have an address?
No, I have a room in the trailer. I just don't know the address because I'm only there a couple days a week. But I do have I pay $100 a week in rent for it.
Does he have any priors?
Yes, Judge. He has a theft from last year. Showing priors out in New York, Pennsylvania. He's been arrested. One's for prior failing to appear in court. These other priors in Florida are dated though, Your Honor.
Mr. Latimer, if you were released, would you be able to give information to pretrial release as to where they could contact you?
Your Honor, we interviewed him this morning. He was unable to provide that information. All he indicated that he rents a room in a trailer. He doesn't know the address where it is located. He doesn't have a contact number for the individual from whom he allegedly rents this room in the trailer. And according to his booking report, it says at large.
Judge, he doesn't know, like he told you he was honest, he doesn't know the exact address, but he could tell pretrial to cross.
That was my question. That was my question. My question to...
I think pretrial wasn't answering. They were telling you as far as some other stuff.
Mr. Romero. Mr. Latimer, would you be able to, if you were released, give pretrial release after your release where you'd be staying? Would you be able to contact them and give them that information?
Within hours, I could make a phone call.
I'm going to ROR him on all counts to pretrial release level 1. He is to report by phone twice a week.
Wait, Your Honor, level 1 is GPS.
I keep saying that. I meant standard. I'm sorry. Thank you for correcting me. Standard pretrial release, he is to report by phone twice a week, and he is to provide that information as to where he'll be residing to pretrial release.
He must report to pretrial on or before 12 p.m. tomorrow.
Mr. Latimer, if you are, when you are released, you must report to pretrial release that's across the street by 12 p.m. tomorrow, okay? That would be noon.
Correct. This is the map. It's across the street. You have to go there before noon. When you show up before noon, bring the address and all the information as far as that trailer where you're going to be residing, okay? If not, one's going to be issued for your arrest. All right? Good luck, sir.
There you go. I signed those. George Magnon?
She's a medical reset, Your Honor.
Okay. Do you want me to write on there, medical reset? Or? Yes. Okay. Jose Gonzalez?
We already did him, Judge. He was this, who requires Spanish interpreter. Oh, here he is. Antonio Gonzalez? Jose. Oh, Jose. I'm sorry. I misspoke, Judge. It's my error.
All right. Mr. Gonzalez, you're presently charged with battery on a law enforcement officer, a third-degree felony, and resisting or obstructing without violence, a misdemeanor. I've read the probable cause affidavit. I find probable cause. Just give me a moment to refresh my memory. State, I'll hear you regarding bond.
The state would request a $10,000 bond.
Or if you just have one moment.
Sure. Mr. Romero, can you give me a background on Mr. Gonzalez?
I sure can. He's been residing here his whole life. He's 28 years old. He works for a company called Jet Runway Cafe. He's a busboy there. He makes approximately $6 plus tip. He lives in Sunrise. He lives with his mother. His mother is a caregiver, so that's who he's going to be contacting to post his bond.
What kind of bond could she make?
He believes, he's not for certain, but he believes she can afford somewhere in the neighborhood of $1,500, but he's not positive, so that's why he would be asking respectfully if you would consider pre-trial relief.
Mr. Gonzalez, I'm gonna set your bond on the battery, a law enforcement officer, at $1,000 and the resisting at $250. Okay, and what about Tyler Holler? Tyler Holler.
Judge, I've got a PC argument as to count 2.
Mr. Holler, you're charged with petty theft. It looks like a first-degree misdemeanor. And you're also charged with possession with intent to sell, manufacture alprazolam, $1,000. I do not find probable cause on count 2 as to the with intent to sell, manufacture, deliver. I find probable cause for possession.
Yes, Judge, and I was just gonna make the court aware that, in the PC affidavit, it was charged as possession of a controlled substance.
Okay. Can he make the $1,000 bond?
He's advising me no.
Can you just give me some not history, but background on him, where he lives? He lives in New York, right?
I'm in a halfway house down here, sir.
For drugs?
Yes, and those.
Mr. Romero?
Yes, Judge. I'm trying to inquire right now.
He is being treated for a drug addiction, am I correct?
I believe so, yes, Judge.
Okay.
Your Honor, out of the state of New York where he's from, already this year, criminal possession controlled substance. Let's see. Introducing contraband into prison or jail from last year, or 2014. Criminal possession controlled substance, 2013. Possession of hypodermic needles, 2013. And showing
Mr. Holler, where is your family?
His family is in New York, Judge. He's down here, South Florida. He came for rehabilitation.
Right.
He's residing in a halfway house. He's telling me that, unfortunately, at this time, he's not employed. And right now, there's nobody that could post his monetary bond, Judge.
I don't think they'll take him back in the halfway house either, will they?
Yeah, but
I can't imagine them doing that.
but Your Honor, even if they do, it's.
What are you recommending?
Your Honor, at this point in time, and again, he can come back for a second look and we'll see, but at this point in time, I would ask for since he has no ties to the community, recent priors to the same similar offense, and now he's allegedly stealing and in possession of controlled substances, that the bond, $1,000 bond be kept in place.
Okay. And Mr. Romero, what are you asking for? Pre-trial release?
I would say pre-trial release, and this time pending verification. If that halfway house is willing to accept him, then basically he will have a place to be at. He will be getting help for his addiction, and he will be supervised by pre-trial.
Here's what I'm gonna do. I'm gonna set the, leave the bond at $1,000. I'm gonna set the petty theft bond at $150. Mr. Holler, if you can contact, the halfway house and get some information to us, we'll take a second look. Okay?
Judge, you wouldn't consider at this time pending verification adjudication?
No.
Meaning leaving the bonds in place?
Your Honor, what's been,
Wait a minute, wait, I can only listen to one person at a time. I'm sorry, Mr. Romero, go ahead.
I'm just asking if pretrial can verify that he can stay there, then he'll be released to pretrial. If not, the monetary bond is in place.
Okay, and I'm sorry, ma'am, what was this you wanted to tell me?
Your Honor, what's been going on with a lot of these individuals that's in the state of Florida just for rehab, that's from up north? They're being released, then they're being number one, they're being brokered by the different treatment facilities. Then, once they get kicked out of one facility, they're on the streets homeless.
Yeah. Mr. Romero, if we can get any information regarding, for instance, like somebody from the halfway house or the treatment facility coming here and talking with us and verifying that he's going to be going there and custody to custody, all that, we'll take a second look, okay? You want me to reset this for tomorrow afternoon? I'm going to do that. I'm going to set Mr. Haller on a second look for tomorrow afternoon at 1:30. Daniel Ritz?
Just leave them there. We can leave that there.
Daniel Ritz? I guess he's on a
I think
medical,
it's still
He's
a
on-
reset.
yeah, he's a
medical reset? Okay,
Same goes for Garcia.
okay. Okay, so Oscar Garcia also is a medical reset? And the last one for this morning anyways is Mr. Leon Maddox, maybe?
I don't have a PC for him. Do you have a PC?
I have a medical reset thing and, yes, I do.
May I approach?
Sure. Are you Mr. Maddox?
Mr. Maddox, Leon Maddox is here present, Judge?
Okay, I just give me a second, I gotta get my paperwork back. And I signed these. Thank you.
Thank you, Judge.
Thank you. Okay. Mr. Maddox, you're being charged with resisting an officer obstruction with violence. I do not find probable cause, but I do find probable cause without violence. You're also being held for loitering or prowling. And Mr. Romero, here's
Unfortunately, Mr. Maddox, he's homeless and he's not working. There's no one that can post his financial bond. He's been residing, he says, in South Florida his whole life. Judge, considering you found probable cause for a misdemeanor, would you consider ROR on Mr. Maddox? He does have priors, he did advise me that, but I believe they're a little bit dated, Judge.
any issue regarding mental health?
Not that I'm aware of, Judge.
Mr. Maddox, good morning, sir.
Good morning.
I see that you don't really have a place to live, is that correct?
That's correct, sir.
Do you have any family in the area?
No, sir.
Do you understand what you're being charged with?
Not really. What am I in charge of, sir?
Okay, well, do you know who I am? Do you know who I'm supposed to be? Who's talking to you?
You're a judge.
Oh, okay. Do you know where you are? Where are you located right now?
I'm in the county jail, Broward County Jail.
All right, do you know who the man is standing next to you?
He's a public defender.
Okay. All right, well, they've charged you with resisting or obstructing a law enforcement officer without violence and loitering and prowling. Those are the two charges. They're both misdemeanors.
Your Honor,
Yes.
he was arrested for resisting with. I understand the court found probable cause for lesser, but it still remains that he's been arrested for resisting with until the state makes unless the state makes a filing decision to downfile it.
Judge, I'd have PC argument even as for the without and the loitering. I mean, from what I read, they had a bolo. They were looking for a suspect. They came across this individual who they believed somewhat matched someone that they were looking for. They initiated the contact with this individual. I don't know that they were inside the legal duty to do so. I don't know what the act of loitering or prowling is, that he was sleeping. I'm glad that the court made the findings that it was without violence because I did not see any, but I still even have probable causes to the whole arrest. I would imagine there'll be a motion to suppress or dismiss. It'll be filed at some point, but obviously that's not for the court to hear at this time.
What is the state's recommendation regarding bond?
Your Honor, well, I haven't had an opportunity to check if, well, I don't know, frankly, I don't know if it's Mr. Maddox or if it's Mr. Holston, because he's gone by both, and it's on his booking sheet. He has had priors for 2012, a battery that was pled down from a battery on a law enforcement officer, theft, loitering and prowling, burglary of a residence that he went to state prison on. Your Honor, state would be requesting a $100 bond on resisting without violence.
And on the loitering?
Your Honor, I'll leave that in the court's discretion, whatever bond the court deems appropriate, or whatever condition, release condition.
And pretrial, do you have any information on this gentleman or any kind of recommendation or position? I suspect
Let
the,
me check the notes to see what the notes are from this morning.
okay, I suspect a severe alcohol problem. He's homeless. Certainly I see probable cause for loitering and prowling and resisting without violence. Mr. Maddox, let me ask you something. How would we notify you of a court date?
Your Honor, he is homeless.
Right.
And he does indicate that he has no family or friends in the area.
All right, what I'm going to do is I'm going to grant the state's request. I'm going to set a $100 bond on count 1 and ROR on count 2. All right, Mr. Maddox, thank you. All right, anything else? I know we have the domestic violence this afternoon at 1:30, if they can get them up.
Your Honor, it has nothing to do with any case on the docket. I was advised by Broward Sheriff's Office, there were a couple of cases that Judge Malika yesterday ordered bond revocations. Whoever the ASA was didn't provide orders. Does the court have any issue if I were to prepare orders, if the court would sign them? I can tell you, and I can show you the findings from Judge Malika where she wrote revoke on her findings, so if the,
No, I have no problem with that. You can give them to me this afternoon?
I'll have them done in just a couple minutes, if it's okay.
All right. Anything else? Anybody? Okay, so we're, system is off, we're off the record.